So we've discussed the science, now we need to discuss the legalities. One of the hurdles to ensuring that honey in South Africa is in fact authentic and is tested correctly is our current legal framework. The honey regulation is more than 20 years old, and it's time to give it a review. To tell us more and to help us to understand how complex the legislation is, we're going to be chatting to Janusz Luterek from Hahn & Hahn, and he's going to dumb it down for us non-lawyers so that we can appreciate how complex the legislation actually is.
So today we'll be presenting on the review of the South African regulatory and legislative aspects of honey. This is obviously a very big topic at the moment, and there's been a lot of talk about adulteration of honey, what honey can be called, what the grades are of honey, and hopefully I can shed some light on that today. So the relevant sources in South Africa are R835, which are the regulations relating to the grading, packing and marking of honey, and this is the one that most of you will be familiar with. The next one we have to be considering is R146, which are the regulations relating to labeling and advertising of foodstuffs, not forgetting that honey is of course a foodstuff. Then we have the South African National Standard 289. That is the so-called weights and measures. Many of you will be aware of that. It tells you how you must indicate the volume of a product on packaging, the size of the lettering, whether you can use various configurations and so on. The Consumer Protection Act is also very important because that is a law which ensures that consumers are not deceived or misled. And then finally, when no other law applies, we can fall back on the Codex standard for honey, bearing in mind that Codex is not part of South African law as such and can only be fallen back on when there is nothing else in our law. So, what is honey? What type of honey are we talking about? Let's go through some of the basic definitions in terms of the R835 honey regulations. So firstly, in these regulations, there are various definitions on the names permitted to be used on the label of a honey product. And many of you will be out there and you will see the most amazing names on honey products. Now, I don't want to name anybody because some of you may be actually watching this and may be very embarrassed. So there's chunk honey, comb honey, creamed honey, crystallized honey, cut comb honey, extracted honey, filtered honey, floral honey. Now, floral honey is an interesting one, and it's also sometimes called blossom honey, and it means any laboratory honey derived essentially from the nectar of flowers. And I think it's quite important, the word there is essentially from the nectar of flowers. We then have a definition of honey as such, which means a sweet foodstuff derived from the nectar of flowers, sugary excretions of insects, plant juices or sugary secretions of living plant parts other than flowers, after it has been gathered, partially converted and stored in the comb by honey bees or stingless bees. We have honeydew honey, which is in fact not the same as honey, and you'll see from the definition it's slightly different. And then we have probably the one that should appear more on the shelves but doesn't, which is honey substitute. And there are quite a number of products out there which we consider to be adulterated honey, which in fact could be considered to be a honey substitute. And that would mean any foodstuff consisting of a food substance or a mixture of substances that have been made to resemble honey. When you go to a coffee shop and you ask them for honey with your coffee, be very careful, read the label. You may in fact be given honey substitute and not honey. We have a definition of irradiation, and we all know that if you're importing honey from various countries into South Africa, it has to be irradiated for phytosanitary reasons. We have liquid honey, raw honey, ripe honey, strained honey, sugarcane honey, unheated honey, and then various bee products which obviously are other than honey. Beeswax, propolis, royal jelly, etc. So I just zoomed through that because you're going to get this presentation and you can read those definitions for yourselves. We've gone through them so that you can understand when we discuss the grading of honey later what all these terms may be. Let's now look at the types of claims which may be allowed. So the Food Labelling Regulations R146 defines a claim in relation to a foodstuff as meaning any written, pictorial, visual, descriptive or verbal statement, communication, representation or reference brought to the attention of the public in any manner, including a trade name or brand name, and referring to the characteristic of a product, in particular to its nature, identity, nutritional properties, composition, quality, durability, origin, or method of manufacture or production. So various claims regarding to honey may in fact be contravening this definition of a claim, because a picture on a jar of honey indicating it comes from a mountain or that it comes from a certain tree or a certain blossom may in fact be contravening this. Then we've got comparative claims, which is a claim that compares the nutrient levels or energy value or alcohol level of two or more similar products. We have a nutrient content claim, and then we have a nutrition claim. And obviously, if you're making any nutritional claims on a product, they have to be substantiated as is required in terms of Regulation R146. But let's look at misleading claims. So when are claims misleading? So Regulation 9 of R835 refers to restricted particulars on containers. And there it says specifically, no wording, illustration, or other means. So it's not just the wording. Even an illustration can be seen, can constitute a misrepresentation, or which directly or by implication may create a misleading impression of the contents. Are you misleading the consumer to believe the honey has an origin it doesn't have? Or for that matter of fact, that it's honey when it's in fact honey substitute? And none of these shall appear on any container containing honey or mixtures of bee products. The word honey or any representation thereof may not appear anywhere on any honey substitute, its label or packaging. And should a honey substitute contain any honey, then the word honey shall only appear within the list of ingredients. There are quite a number of products on the shelves, some that have been served to me in person, which would contravene this due to the way in which the word honey is presented on what is otherwise a sugar syrup with a little bit of honey in it. Except for honey and mixtures of bee products, no other product may have its label, packaging, trade name, trademark, or pictorial illustrations so designed as to imply that honey is a main ingredient. Please note, you cannot go and register a trademark which would imply that there is honey present in the product and then try to rely on the fact that you have a registered trademark. It's simply not allowed. And then except for the trade name, Radura symbol that relates to irradiation, pictorial illustrations, logo or registered mark, marking requirements prescribed in Regulation 8, additional marking requirements are allowed by Regulation 11. And these include information in respect of crystallization and the liquefaction of crystallized honey and the chemical composition or nutritive value. No other name, mark, description, advertisement, or claim as to the qualitative properties or otherwise of honey are allowed to appear on a container of honey or mixtures of bee products, on its lid, cap or stopper, or on the label or on any leaflet, however attached to the container. So I think we need to be very careful. There's a lot of products out there which don't comply, and that shouldn't be the norm. Those products should be taken care of, and the regulator should deal with it. Let's revert back to the labeling regulations R146. So R146 says that the pictorial representation on the label or advertisement of a foodstuff may not be presented in a manner that is false, misleading, or deceptive, or likely to create an erroneous impression regarding the contents of the container. So it builds on that prohibition in R835. In fact, both of them have to be complied with. Then we have Regulation 47 under R146, which says, any word, statement, phrase, logo, or pictorial representation which implies a message of being healthy or healthier or additive-free or veterinary medicine-free, or that it's pure, etc., will only be permitted on the prepackaged labeling and advertising of the products if they are registered in terms of a protocol under the Agricultural Product Standards Act. So the APS Act applies when it comes to honey, and accordingly specific prohibitions in terms of Regulation 9 of R835 and stipulated above are applicable, as well as all the prohibitions in terms of the food labeling regulations. Let's look at geographic origin, because this is another interesting one. People make various geographic origin claims. And Regulation 3 deals with the prohibition on the use of registered geographical indicators. And it says that any direct or indirect commercial use of a registered geographical indicator in the Republic of South Africa is prohibited on similar agricultural products which are not covered by registration, and dissimilar agricultural products with such use exploits the reputation of the protected name. I presume an example of this would be something like Manuka honey, which comes from a very specific geographical region, and use thereof on honey from other regions would in fact contravene this. So the prohibition referred to above applies in particular where the registered name is imitated or eluded, where it's translated, where people try to say, oh, it's in the same style, it's in the same type, it's an imitation of it, it's a method, it's produced in accordance with a certain method, etc. But it'll only be permissible where there's specific allowance for it in international agreements. It will also apply to false or misleading indication or depiction of the product's true origin, provenance, manufacturing process, nature, or essential characteristics of the product. And any use of a container or packaging which creates such a false impression, and any illicit use of a GI symbol, the designation, etc., is a prohibited conduct. The executive officer may, however, under very specific conditions, grant a written exemption, but that is only if you apply. You can't just start using it and then try to apply later. Let's look at the DALRAD website regarding the EU SADC list of geographical indicators, and the website link is there. And you will need to check regularly to see if new products haven't been added and their geographical indicators protected. Then we need to look at different origins of honey, such as floral, etc. So any container containing honey or mixtures of bee products shall be clearly and legibly marked with the following particulars: the name of the product in letters at least 4 mm height, provided that a true reflection of the kind of honey contained therein, such as creamed or chunk, the floral or plant source such as sunflower, buckwheat, honeydew, or any other similar description, such as the geographical indicator, etc., may be used additionally. But we should remember that it can't be misleading. So if you have a very low percentage of a specific floral origin, you can't then call that product as being that floral honey. For example, orange blossom, but yet there's only a very minor percentage of orange blossom origin honey. The word irradiated needs to be applied if the honey has been irradiated. Can sugar be added to honey? There's a question. So the answer in short is yes, but then it will become a honey substitute and is no longer called honey. One has to look at the definitions of honey, which we dealt with earlier. So regulation 9.2 is very important, and you cannot call something honey if it's a honey substitute. And should the substitute actually contain honey, the word honey may only appear in the ingredients list. It can't be on the front of pack as part of a trademark, as part of a product name, or in any other way. You cannot mislead the consumer on the label, and this is also borne out by the Consumer Protection Act, which is there to protect consumers against being taken advantage of. And Section 24 says, a person must not knowingly apply to any goods a trade description that is likely to mislead the consumer or in a manner calculated to mislead consumers. The responsibility of a retailer is not to offer to supply, display, or supply any goods if the retailer knows, reasonably could determine, or has reason to suspect that a trade description applied to the goods is likely to mislead the consumer. So please note, this is a retailer's responsibility, and if the retailer has only even grounds to suspect, they need to take action and remove the product from sale. There are also general standards for marketing of goods and services under the Consumer Protection Act, and a producer, importer, distributor, retailer, or service provider must not market any goods or services in a manner reasonably likely to imply a false or misleading representation concerning the goods or services, or in a manner that is misleading, fraudulent, or deceptive in any way. Go and have a look on the shelves in your supermarket, and you decide if you think that some of those, in fact, are contravening the Consumer Protection Act. And of course, that would be in the case of the nature, the properties, or any other material aspect of the honey. So it could be claims to its origin, it's a floral blossom of some sort, it's claimed to be orange blossom or lemon blossom or some sort of fruit, but in fact it's not. Therefore, it will be a material aspect of the goods. And the Consumer Protection Act further goes to make it a prohibited conduct to make any misleading or deceptive representations, either directly or indirectly, but to express or imply a false, misleading, or deceptive representation considering a material fact, or even using exaggeration, innuendo, ambiguity as the material fact to mislead a consumer. So it's very important that without limiting the generality of this, the Consumer Protection Act specifically prohibits any claims or statements, etc., that any goods or services have ingredients or performance characteristics, uses, benefits, or qualities that they do not have, or of a particular standard, quality, grade, style, which they are not. Now, the Consumer Protection Act is very important because in terms of the Consumer Protection Act, you can get a 10 million rand fine, 1 million rand fine, or 10% of the total turnover of the company if you're a contravention of that. Finally, R146 includes honey in its definition of a single ingredient agricultural commodity. As soon as you add something to it, of course, it's no longer a single ingredient, and then you no longer can rely on any exemption under the labelling regulations. And then under the labelling regulations, we've got the allergen-related claims that no claim shall be made on a foodstuff that it is hypoallergenic or non-allergenic, etc., unless the foodstuff is modified by chemical or genetic means so as to reduce the quantity of endogenous allergens in such a way that it is not possible to detect the presence of any possible allergen. And so therefore you cannot simply go and make claims on a honey if nothing has been done to it and it is in its natural form. In terms of the nutritional information, as soon as you make any health claims on a product, or any other, not health claims, nutritional claims on a product, you immediately have to provide a nutritional table. Otherwise, you can rely on the single ingredient agricultural commodity tables from the MRC, but only if it's a single ingredient commodity. And what are the exemptions? Well, there's an exemption to a lot of the labeling requirements under the Foodstuffs Act, the R146, but only if you are a single ingredient commodity. So as soon as you add anything to it, this exemption falls away. So let's look at a question which we were asked. South Africa only has one grade of honey. The rest of the world is 3 to 5 grades. What do we think about it? So Regulation 5 of R835 says that there are 2 grades of liquid honey, creamed honey, and comb honey. And that is simply choice grade or industrial grade. There's 1 grade of chunk honey and mixtures of bee product, and that is choice grade. There's no grading of raw honey. Now, the fact that other countries have different grades has no impact at all on us. We are in South Africa, we fall under South African law and regulations. If we want to do things differently, we would have to deal with the department and have the regulations rewritten. It's not a defense to non-compliance to say that in another country they have different grades than we have. If you want to import the product into South Africa or sell it here, you do have to comply with our grading regulations. Regulation 5 continues and it says crystallization does not result in downgrading as it's a natural process. And when any quality of the factor for standards of cream or crystallized honey is in dispute, a sample shall first be liquefied and then graded. And there we have the requirements for the grading, and I'm not going I'm just showing you that they're there, they're in the presentation. You'll be able to read these for yourselves later. So South Africa has different types of grading depending on the type of honey, but specifically as it was in the regulation. And according to the table, one can then determine what the grade is that your product has to comply with. Finally, we were asked, so I've spoken a lot about all the non-compliant product that's out in the market. So what happens? How does the Department of Agriculture, Land and Land Reform deal with non-compliant product? And what is a product seizure? So under the Agricultural Product Standards Act, the inspector or the assignee will issue a directive to comply, and they will set you a deadline. Typically, they'll give you, say, 30 days. They'll say your product label doesn't comply. You have 30 days to remove the product from sale. But of course, there are instances where it may be immediate if the non-compliance is so egregious. When this happens, you can try and apply to the executive officer and ask for a dispensation, or you can resolve the problem by fixing it, e.g. over-label, change the label, fix the label. If you do not get a dispensation and your directive runs out, the department can go and do a seizure. They issue a seizure notice, which means straight away your product can no longer be sold, it's got to be quarantined. And once your product has been seized, it's too late. No dispensation is possible at that stage. All sale must be stopped immediately. The only remedy at that point is to rectify the problem or to discard the product. At that point also you can be prosecuted and fines or even imprisonment is possible. So what is a dispensation? Well, a dispensation is in fact a limited right not to comply with a regulation, and it's an extraordinary procedure. There's no right to get a dispensation. It's a formal procedure. There's a form that has to be completed. There's a letter to the competent division explaining the circumstances. My practical experience has been to try and organize a prior meeting to discuss the issue. Generally, you ask for a dispensation for a transitional period while you're resolving the problem. But just remember, any dispensation is an admission of guilt. You are admitting your product is incorrectly labeled and you're asking for leniency. You cannot thereafter try to go back on that and claim that your product is in fact compliant. So seizure of products, they can seize some or all of the product in the market, they can seize your substances and articles, etc. in your factory, they can even seize your books and your documents if imported to prove that you're not compliant. They may afford evidence of the commission or suspect commission of any offence, and even if it's only intended to commit an offence. So if they come to your factory and you've got a whole lot of labels which are false, they are going to mislead the public, they are contravening the regulations, that in itself can be proof of an offence. But if they never prosecute you, they've got to return everything to you. And finally, so what is an appeal? Maybe you can appeal. So if you disagree with what's happened in terms of a directive, an appeal process is set out in the Agricultural Product Standards Act, and you have to lodge an appeal and pay the prescribed appeal fee. But here's the kicker. Within 10 days, the appeal regulations were amended in 2019 and the 10-day provision was put in. You cannot get a directive and 2-3 months later try and appeal. It's too late. When you get the directive, you have 10 days to appeal. An appeal board is appointed, and the decision of the appeal board, together with the reasons therefore, shall be in writing, and the appeal board can either confirm the directive or seizure or make another ruling altogether. Thank you very much. If you have some questions, you can always email me. Remember, there's no such thing as a stupid question, but also equally remember, not all questions have an answer. Thank you.